All right. I think I'm going to get started here. Vargo, can you just confirm that you're here? Maybe jump on camera for a sec.
Yep, I'm here.
All right. Everybody. My name is Chris Sarek. I'm the Deputy Director, Executive Secretary of the Alcohol Tobacco Commission, and I have our legal team here with me, Melissa Beaucaire, our General Counsel, Daphne Whitmire, our Senior Attorney, and Alex Vargo, of course, is my partner in legislative liaison work, and he's also the legal officer for Excise and ATC. And then Lorianne Shelton is our trustee tobacco processor, director, all things tobacco. So she is also here in attendance to help vet questions and collect input. So before I get started in earnest on content, my goal here today is to obviously overview the changes in law for 2026 pertaining to tobacco specifically. But I think even more importantly than conveying that information, which I've already done in part in our full legislative update webinar, I really want to collect input and get questions from industry members who are out there actually having to comply with these new laws, so that we can really best implement, especially the big changes like the wholesale tobacco certificate and the e-liquid manufacturing permit. Those are two, especially the e-liquid is a big change for the state of Indiana. So we want as much feedback on the front end as we can get. Your concerns, all of that is on the table, so that we can take that information and then maybe modify how we had planned to do things on implementation. So along those lines, it's important for me to note on the front end, I am an attorney. I'm joined here with attorneys. However, we are not your attorneys, and we cannot give you legal advice. In fact, any information that we provide is purely informational. It cannot be relied upon as a legal analysis or formal position of the state of Indiana as to statutes. That being said, we can certainly tell you how we interpret things and how we will implement those things. So this presentation is important in that sense. And then also, we're going to outline some of the operational details on how we plan to actually go about implementing and enforcing these new laws. Again, this is all subject to slight or major modification based on experience, based on inputs, and just based on the realities we're dealt with. So I don't want you to take anything today as necessarily gospel. It's certainly something you can rely upon as direction going forward in terms of our plans for implementation. But just know that things might change slightly as we learn, because we want to make sure that we are responding to the realities that you guys deal with out in the field and that our officers and staff deal with in the civilian side. So here is a table. This is just all of the legislative changes, all the bills and all the impacted code sections. It looks a little blurry on my screen, but it's not blurry in the actual presentation. I might zoom in actually. Maybe people can't see that very well. Can ATC team, do you want me to zoom in a little bit on the presentation? I'll take that as a no then.
Yeah. Looks good to me, Chris.
Okay.
You're good.
Okay, cool. Getting started then with our first bill that has tobacco-related provisions is HE 1052. This was ATC's agency bill, and it became a little bit more than just our agency bill and got some stuff added that wasn't necessarily agency promulgated. However, it has some important and positive changes for the industry and for the state of Indiana. The big one that we're all really was the impetus, along with e-liquid, for me setting this up today. And I think all the industry reps out there who reached out to me and asked for this forum, it's really positive, and we want to partner, obviously, just like we have with drafting legislation and passing legislation. We want to partner as we implement and enforce the laws as well. Our goal is to create a safe, healthy marketplace. Get people having adverse impacts on their business and permits is never our objective. So we want to make sure everybody knows the law and we can do this together and accomplish the goals that we have. So with the wholesale tobacco sales certificate, current law provides that retail tobacco purveyors have to get a TC, a retail tobacco certificate, from the Alcohol Tobacco Commission, and cigarette manufacturers. There is no wholesale tobacco sales certificate under present law. from ATC's perspective that ATC owns. There is only the DOR cigarette distributor license, and DOR has no enforcement capacity. They have no enforcement ability in terms of having officers on the ground and real authority to suspend and revoke those cigarette distributor licenses. So there's a real regulatory gap in the state of Indiana in terms of the distribution of tobacco products. So our goal in adopting this new requirement is to ensure that ATC has a direct regulatory nexus to tobacco distributors. So if you are selling tobacco to other certificate holders in the state of Indiana, if you're located in Indiana or not, you're distributing into the state to other certificate holders, you need to obtain this new wholesale tobacco sales certificate from the Alcohol Tobacco Commission. Well, this is effective July 1. We are going to put a tentative drop dead date of November 1, 2026 to give some lead time for industry to recognize the law change occurred and apply to us and for us to process permits or certificate applications. So right now we're saying November 1. We might push that back if we need to, again, trying to be responsive to the realities of the industry and in your business day to day. And this is required, this wholesale certificate is required in addition to the existing DOR cigarette distributor license. You have to hold both. The terms of the new wholesale tobacco certificate is 1 year in duration. So this is different than the retail in the sense that you got to renew it annually. It's a $100 fee for both the new certificate and for each renewal, non-transferable, and it's got all the same requirements as the retail TC. So really all they did in the code is add the word wholesale everywhere that it talks about the retail, and then of course build out some sections specifically to create the wholesale certificate. So that means that all of those requirements that apply to a retail TC, all of the qualifications, etc., also apply to the wholesale. Only difference being that duration, really. So the application process is going to be fully online using My License One. Tobacco certificate holders, you guys are used to that. The application is going to be essentially the same as the retail TC, slight content changes. We already have the application. It's in testing, so we're well ready to move forward with getting that implemented by July 1, and hopefully we can even launch it early so that people can start applying. And it's important to note too that wholesale and retail certificates, they can be issued to the same owner at the same location. So you can hold a TC, a retail TC and a wholesale TC for the same address, same location. You just need to maintain your business operations separately. And we'll talk a little bit about that in a sec. So in terms of implementation of the wholesale certificate, our plans again are to do educational enforcement until November. So that is to say, if we were to visit or come into contact with a tobacco distributor that did not have a wholesale tobacco certificate yet or had not applied, then officers would educate them as to the requirements in the law and just let them know they need to obtain this wholesale certificate by November 1. So after November 1, we're going to have to start actually citing and doing normal enforcement and compliance activities. Again, within reason, our officers are always going to be reasonable in working with industry members and permanent partners. The application will be online only, same as retail. And as it stands right now, we need to require a separate wholesale certificate for each wholesale location. So if you have multiple facilities across the state or out of state that distributes into Indiana, then you would need a certificate for each of those locations. We might track with the master and location structure. We're still kind of working all of that out, but for the time being, it's just easy enough to apply for a wholesale certificate for each location, for each facility. And then in terms of the operation of a retail and wholesale business separately, so if you're an existing TC, a retail, it's going to take me a long time to not say TC to refer to retail tobacco locations. TC refers to both now. So if you currently have a retail TC and you're also doing a wholesale business and you're going to obtain a wholesale TC from ATC, you need to make sure that those businesses are operated separately. Now, I understand there's probably already intermingling of inventory, and space is probably co-used for both businesses. The important point is not so much that you have inventory separated out. It's more that you maintain strict separation in business records and invoicing so that you can clearly show to the ATC, here's my wholesale business, here are my sales related to that, here are the products that I've sold and to whom and at what price. And then also on the retail side, here are the products I sold direct to customers in my storefront, and all of that information being maintained separately. Again, they have to be distinct, the businesses. You need to have independent invoicing business records. And then it's important to note that wholesale transactions are just defined as transactions between tobacco certificate holders, not direct to consumer. That would be a retail transaction. And then inventory, I know I say that it can cohabitate and it can, but within reason, it would be ideal if we could have the wholesale inventory and the retail storefront inventory maintained separately. To the extent that there's no self-service as it is with tobacco products, I don't see that as being too much of an issue in terms of the commingling, just as long as it's clear what is part of the retail and what is part of the wholesale business. And at the end of each bill, we'll open it up for questions and do a Q&A. I hope to have a robust Q&A. So put your questions in the chat, and then when we get to that slide that asks for questions, which is coming up, then we can answer those questions at that time and have a discussion. So think about your questions now and start entering those in the chat. There are a couple other changes, that were made to tobacco certificates in HEA 1052. First off, as I said at the beginning, the word certificate now refers to both a wholesale and a retail tobacco sales certificate. So when we say TC, it could mean either. So we need to say wholesale TC, retail TC to refer to each distinct tobacco certificate type. And then the word TC obviously still means tobacco certificate in our vernacular. So the word certificate and the code now means both retail and wholesale. We've also implemented, and this is a new requirement, an ID requirement for new and renewal tobacco certificate applications, both wholesale and retail, So what this means is that a copy of valid identification needs to be provided for individual owners of the business, of the applicant business. If there are multiple owners, and especially if you have diffuse ownership through shareholding or equity stakes where you have passive investors, passive shareholders, we're not so interested in those individuals because there's no prohibited interest considerations in this context. We're more concerned with the operators, the individuals who are really behind the engine of the business, who are managing the day-to-day operations or managing the overall business operations. So if you have multiple owners, we want a copy of the ID for the owners that manage the business operations, the owner that signs the tobacco certificate application, or if you have a power of attorney that you granted to a preparer, then the individual who signed that power of attorney, that would be a person who you could provide the ID for. We don't need IDs of third-party preparers, and if those are provided, those are not adequate to satisfy the ID requirement. The purpose of this requirement is so that we have an actual verifiable identity associated with each certificate. As it stands currently, that's not something that we can track very well because of the lack of data that we have about ownership on the TC side. Let me say one thing about implementation on the ID requirement. This will be submitted when you renew. So if you're an existing retail TC holder, you don't need to supplement your existing application. Just when you apply for your renewal, then you can submit the ID with that renewal application. And then if you applied for a new TC retail or wholesale, you would of course need to provide the ID information at that time. So a couple of new TC compliance provisions were added to the code. The big one for ATC and trying to crack down on some of the bad actors who are not going to be present on this webinar, because the people who are here are wanting to proactively comply with the law. So these are not the people who are going to be impacted by this change. But if you have a TC revoked, retail or wholesale, then a new TC cannot be issued for that location for 12 months. So if there is activity violations that are egregious enough to get your tobacco certificate revoked, then that address is salted soil for tobacco certificates for 12 months. Can't reapply. Can't obtain a new one. Only exception is if the underlying real estate changes hands via an arm's length real estate transaction. So if Bill gets his permit revoked and then sells it to his brother Bob, the real estate to brother Bob can't apply for a new permit there because that's not an arm's length transaction. You have related parties. Needs to be like Bob, puts the property up for sale and Jim from another city comes and buys the property and they never met before, So the idea being there that we don't have a bad actor who has had their permit revoked simply use a new business or use a friend or family member to obtain a TC for that same location right away. Right after they've had their permit revoked, they're going right back into business. And the law currently, it doesn't prevent that. So we had to make this change in order to prevent those sorts of shell operators, which are rare, but they exist in enough of a quantity to make this a real necessity. It's important to note, again, that the owner of the revoked TC, they can't have any ongoing role in the operation of the new TC if there is a real estate transaction. So going back to my Bob and Bill example, if Bob has it revoked and sells it to Bill, who's an independent third party, Bob can't then operate the business for Bill. Bob can't have any role in the operation of that TC at that location. Now, if Bob has his permit revoked and then 12 months later, he can apply for a new TC at that location, that's not a problem. And he could operate businesses at other locations after the revocation, just not at that exact same location. We also made a change. Currently, material misrepresentations of fact on a TC application can only result in the suspension of the tobacco certificate. We added the option for the commission to revoke that a TC for a material misrepresentation of fact. We also added some automatic suspensions for violations of the requirement that TC employees selling tobacco produce a valid ID to law enforcement within 5 days. We've talked about this requirement ad nauseum the last couple of years. I think everybody's familiar with it, but just to rehash quickly, if you are an employee of a tobacco certificate holder and you are selling tobacco in that business, law enforcement comes in, says, Mr. Clerk, show me your identification. If that person can't produce a valid form of identification, then they're going to get a warning, and then the officer's going to come back in 5 days. If they can't produce the ID after 5 days, then that's going to be a citation to the business. If you have 3, 4, or 5 citations, violations for this ID requirement in the same 12-month period, you're going to get a 5-day suspension each time. So third violation equals 5 days, fourth violation equals 5 days, fifth violation equals 5 days, separate 15 days total. If you violate for a 6th time in 12 months, it's an automatic revocation. And this looks a little bit like the habitual offender status that we have pinned to sales to minors. So you'll see in a sec that I think it's in another bill, but in SCA 195, we changed the habitual offender status from 6 violations in a year to 3. So this tracks with the old habitual offender status of having 6 violations in 12 months equals revocation. So do we have questions? Melissa or Daphne, have you guys been tracking the chat?
Yeah, I can go through and read the questions if you want.
Yes, that would be fantastic.
Okay, so the first 2 I think are similar, so I'm just going to combine those. We have one from Miss Helen Hayes and then Robin Sorrow. To confirm, if we are solely a distributor inside or outside Indiana, we also need to obtain this wholesale license, correct? And then
Correct.
Robin's question is, if wholesalers are out of state, do they still need a wholesale license? So I think the question is about the out-of-state wholesalers.
Yes, if it's a wholesale business that's selling product into the state of Indiana, they would need to be certified by the state of Indiana. They would need to obtain a certificate. Yes.
Next is from Patrick, confirming there is nothing new for a retailer locations to do, correct? Because we self-distribute. In the past, we've had enforcement agents in other states expect us to have the distribution license posted at the retail location.
If you are distributing product to another certificate holder, so if you're self-distributing to customers, that's fine. But that's a retail. But if you are selling to other TC holders, you would need to have a wholesale certificate as well as a retail if you're doing both. So the key here is, are you selling tobacco to another certificate holder? If yes, must have wholesale certificate.
Okay, next is from Ross. What situation does a retail store need a wholesale license? If our distributors don't have Indiana wholesale TCs, then do we as retailers need this wholesale TC to attain our products?
No, and the latter question, the answer is no. If your wholesaler doesn't have a wholesale permit, they need to obtain one. So to the extent that you guys are willing to help us out in that regard, maybe inform them now that they need to have a wholesale permit in order to keep selling in Indiana. Otherwise, they're going to be operating without a certificate here after July 1 and after our educational enforcement period. If you are buying from a non-certified wholesaler and they continue to be non-certified, you need to find a new distributor. I don't foresee pushback from out-of-state distributors. This isn't an expensive permit, and it's necessary in nearly every other state that I'm aware of, that a distributors have to be certified just like retailers. And every wholesaler today should have a DOR distributor's license anyways. So, but that is, if you are a retailer and you're just operating a retail storefront where you're selling direct to consumers, you don't need a wholesale permit or certificate.
Okay, next is from Decatur County. If we sell nicotine products in our jail commissary, but we purchase these items from a distributor, do we need to apply for any type of license?
You are selling out of a commissary. That is a novel question for me. I don't think there's any.
Chris?
Yes,
Chris,
thank you,
it's-
Alex. Alex to the rescue.
Chair, if you
Go
want
ahead.
to jump in there.
I would just say that anybody, including commissaries who are selling nicotine, tobacco, e-liquid, have to have the retail permit.
That's what I was gonna conjecture, but I'm glad to get that confirmation. Thank you, Jessica.
Okay, for
Please,
wholesale
yeah.
sales, oh, go ahead, Chris.
I was gonna say you just need the retail for the commissary. Go ahead.
For wholesale sales into the state, are we required as an, I think, out-of-state wholesaler to collect and remit the excise tax, or can we pass the liability to the wholesale customer in Indiana?
That is really a DOR question, I'm sorry to say. Jessica, are you comfortable weighing in on that, or should we? I'm gonna collect questions that are DOR and then I'll get back to this group with my answers.
I think that's probably right. Who pays the tax would be a statutory interpretation question for DOR.
Yep, agreed. Okay, well, I will pass this along to our partners over at DOR, and then we'll take down who asked the question and make sure that we respond with an answer. What I'll probably end up doing is just collecting those questions that we can't answer today, compiling the answers, and then sending them in an email to everybody that's on this call.
All right, next is from Kathy. How will ATC track those owners that have had their TC revoked in order to track those bad actors?
Yes, so we will, it's primarily location based in the context of the prohibition on getting a new TC at a location where the revocation occurred. So if there's an address that has a revoked permit, then Lorianne will have to mark that down, and we'll make record that location is not eligible in a independent real estate transaction. But in terms of owners, this is precisely why we need to collect the identification, because we don't have a firm way as it stands today to verify the owner of an individual TC location. So that is how we will track that, is by virtue of having that identification and then just making record in our permit file, certificate files, as to the status of the permit and how many revocations, where the revocations occurred, et cetera, for the owners. Good question.
Okay, next is from Chris. Will the owner of the business be notified that one of their employees didn't produce identification?
Yes, to the fullest extent possible, the ATC will work with the business owner, the owner of record, the manager, whoever that TC person has as their owner, their manager on their application. We will communicate to them Alex Bargo, from an excise officer perspective, can you give us an idea of how a citation like this would work?
Yeah, if there's an instance where there's an issue, generally officers are going to try to get a hold of a manager or owner, even if it's by phone while at the scene, to let them know what's going on, just so that they can identify somebody that they spoke with while there. So that's usually the objective that most officers take.
Great.
Okay, next is from Lori. As a distributor, do we need to maintain any copies of the retailer TC as proof of compliance? And to that effect, do invoices to the store for the product require our TC number, assuming some kind of identifying number will be used to be printed on the invoice?
So as a distributor, the onus is on the individual business to maintain their retail tobacco certificate. If you are a distributor, I mean, you should already be verifying, obviously, that the locations you're selling to are certified to buy from a distributor in terms of having a retail certificate. So I think that would be a really good idea in terms of record keeping to make note of the TC numbers associated with the seller and the buyer. It's a business decision, but it's a great suggestion.
Chris, as a follow-up, retailers are still required to maintain invoices of where they bought their tobacco from.
Yes.
So again, it's not a bad idea to put that TC number on there as well as your tax ID number from DOR.
Good.
All right, so next is from Rob. Are you saying every employee needs a certification to sell tobacco, or that
No.
employees can show TC we have posted?
Yeah, no, nothing has changed in regard to the identification and the employees. There's no employee permit or anything like that. It's just that so your location has one tobacco certificate. That's the tobacco certificate that covers all your employees' ability to sell. But your individual employees, just as they've had to for the last several years, need to have a valid piece of identification issued by the state or the federal government in the United States on them when they're at work selling tobacco products. If they are not selling tobacco products, then the identification requirement doesn't apply. But generally, if you're working behind a counter at a TC location, you're selling tobacco, right? And officers will be able to distinguish there. They don't need to have their own TC. The TC of the location covers it. They just need ID. And a lot of businesses, they, as part of the onboarding process, will make copies of their employees' identification. I mean, every job I've ever had, I've had to provide my ID. So that would be a reasonable approach.
Okay, next is from Victor. Where do I find this wholesale form?
You will find it on My License One, and we will have a link to it. It doesn't exist yet, so you'll have a hard time finding it today. But we will post a link to it as soon as it's done being tested. And it's gonna be just like your retail app, same process online.
Okay, so next, do we need to submit all the owner's ID at the time of new or renewal?
Yes, it says every person who has an equity share in the business. So if you have, again, but let's be reasonable here. We don't want passive shareholders. So if you have 3 partners who operate businesses and they're all involved in the day-to-day operations of the business, we need all 3 of their identification. So yeah, we need all of the owners that operate the business. That would be the answer to that question.
And this is from Helen. If we already have a distributor permit, what is the purpose of also having a wholesale permit for the same
Right.
distribution facility?
That's a great question. So DOR and alcohol tobacco regulate completely different subject matter. So your DOR distributor certificate is for the purposes of taxes and taxation. They have no ability to regulate what you're selling. They have no ability to go in and track your sales so that they can interdict illicit products. The Alcohol and Tobacco Commission is the subject matter regulator of tobacco, alcohol in the state of Indiana. So we have the expertise and also the regulatory enforcement authority as law enforcement to go to a wholesale location and verify that they're not selling marijuana, that they're not selling nitrous oxide or counterfeit pharmaceuticals, whatever that might be. So what this wholesale permit does is it fills in that subject matter regulatory gap, whereas it currently stands, there is no active regulation of wholesale businesses on this in terms of what you can and cannot sell outside of like us getting lucky on a traffic stop or otherwise having an investigation where we find illicit products at a wholesale location. The wholesale permit ensures that we have a direct nexus, a connection to every wholesale distributor of tobacco, and we can go and take their permit away if they are not complying with the law. Can't do that right now. It has to be criminal. Everything would be a criminal prosecution, and it's much more obviously onerous and less effective in terms of keeping the market safe.
All right, this next one's from Victor. I think he's asking to verify the cost of the wholesale TC.
$100.
All right, next is from Melissa. Is the TC wholesale permit the same as the tobacco sales certificate for e-cigarettes that has a TC number issued
It's a separate permit. It's a
by
separate
the
certificate.
ATC?
Yeah, it's a separate certificate and a separate, it covers, so you have a retail, currently we have a retail sales certificate. And that covers direct to consumer sales, right? Convenience stores, et cetera. This new certificate is for businesses that sell tobacco like in bulk to another tobacco certificate holder. So this is like the distributor permit, not the retail. They're separate things. If you have a retail business and not a wholesale business, you don't need to worry about the wholesale certificate. I think that answers it. You asked something else about e-cigarettes. There's a separate e-liquid manufacturer's permit. I see. I think I answered your question. The tobacco sales certificate now refers to wholesale and retail in a broader sense. So you have to distinguish. There's the wholesale tobacco sales certificate and the retail tobacco sales certificate. Two different things, cover two different business types.
Hey, next is from Christine. Is there any additional reporting required with having this certificate?
No.
Do retailers in Indiana have to maintain a bond for the tax certificate?
That may be a DOR requirement, but there's no bonding requirement in 7.1 for tobacco.
Okay, next is from Tia. For clarification purposes, those that sell nicotine products that we buy from a distributor on our commissary, we just need to have the retail permit and not have to apply
correct.
for other licenses.
Correct, yes.
Okay. Mason, at what point will the 30% tax on vapor
I can't answer
liquid?
that one. We gotta ask DOR. I'll ask DOR. I've added it to I've already copied this one down and put it in my notes. I'll ask that question for you, Mason, and we'll get an answer out to the group.
Okay, so next is from Lisa. As a retailer, if we sell to another TC holder, but give a discount, not wholesale, can we continue this way, or do we need to switch to a wholesale TC so they can pay the excise tax?
If you are selling to another TC location, that would be the trigger for having a wholesale permit. You're selling for resale, so.
And Chris,
go ahead, Alex. Yeah, that you may clarify. Go ahead.
If you already have a TC, if you're one gas station selling tobacco product to another gas station, that's not permitted under certain circumstances under Title 6 and Title 24. So need to be careful of what you're doing there, because officers will take enforcement action if you are selling or purchasing from another retailer. So keep that in mind.
Yeah, Lisa, why don't you send Alex and I an email, and we can have a separate conversation to try to help you understand the requirements there.
Okay, next is from Tabitha. When a company has multiple locations under one owner, each with a retail certificate, and transfers products from one store location to another at cost, is this considered a TC
I don't think that would
sale
be,
requiring a wholesale license?
No, I don't think that that is within, because that's an inner business. That's just a paper transaction essentially, right? I mean, you're having sharing inventory between multiple commonly owned businesses. So that's a different concept than selling to outside unrelated tobacco certificate holders. Um, Alex, is there any issue there with like TC to TC sales, like you just had mentioned with Lisa's question?
Sorry, I had to find the
Oh, you're
mute button.
all good.
I would have to double check with DOR, but I believe a lot of people that do common distributing have a distributor's license through DOR as well.
Okay, okay, interesting. That is a good question then, in terms of, Jessica, I don't know if you heard that one or if you have thoughts. It might be something that we talk about as a legal group just for operating consideration and can include it in our written answers. Go ahead, Jessica.
We can talk about it, include it in
Okay.
written answers.
Cool, very good.
All right,
Good
next
question.
is, how do I list owner information when the store is under a corporation?
So the individuals who are the owners of the corporation. So a corporation obviously has members, managers that operate the business. So that goes back to the example that I had in the implementation slide. Let's go back here. So if you have multiple owners, you got corporate ownership. So what you want to think about in terms of whose identification you provide is who is the person who's managing the business operations at the corporate level. So who is operating that business? And think about who on behalf of that business is signing your tobacco certificate application or signing other agreements. Who signed the power of attorney if you have a power of attorney for a preparer? So when you have corporate ownership and you have maybe a small group of members and managers, easy enough, you can provide us the identification for each of those corporate managers and members. If it's a larger group and you have corporate ownership with shareholders that are passive, we just want the ID for the people who are actually operating the business. And as a business owner, you'll be able, I think, to easily parse out who that individual is or individuals are.
All right, next is, I joined very late. Is there anywhere I can review this presentation offline?
Yes. Yeah, we are recording and I will be posting this on our, well, I won't, but we'll be posting this on our website. And you'll be able to watch the whole thing. Yep.
Okay, will there be a filing for the wholesale permit or sorry, start that again.
Okay.
Will there be a filing for the wholesale permit or we will continue filing under the distributor license?
You have to have both. So if you're currently a distributor and you have a distributor certificate license from DOR, you also have to have the ATC wholesale. That's where I was talking about earlier about the subject matter regulation versus the tax regulation. Jessica, did you have some to add? Yeah.
Yeah, I think the question might be, do they have to file their tax information under both?
Oh, okay. No, I would say you just use your distributor's license. Good question. Thank you, Jessica.
All right, next is for
Use your
Victor, which I
DOR
think
number.
is, which is a follow-up from before. I was asking for the distribution cost. Has it changed with this new law?
No.
Okay, and then this one is another question about the 30% tax. So is that
Yeah,
referring
no.
that to DOR?
Yes.
Okay, another one from James regarding
Oh, wait,
the
their store,
30%.
I'm sorry, their store is not charging 30% tax on nicotine products. ATC actively engages and partners with DOR. We have a great, strong partnership there. We need industry help in terms of identifying those stores that are not paying taxes or not following the law, because we can refer those and work with DOR. So bring those to ATC through our complaint process, and we will investigate and work with and refer to DOR for investigation. We do that as a regular part of our business. We know that's happening, and we are trying to help enforce that. This is where I was talking earlier about DOR not having that enforcement arm and why the wholesale tobacco certificate is necessary on the ATC side. DOR can't go out there and do much outside of criminal proceedings. So go ahead, Melissa.
I was gonna say, I think James had a similar question about bad actors that aren't collecting the 30% tax, so same answer there. This is from Ann. If multiple locations are owned and we move product from store to store, will a wholesale license be necessary? I think that's a repeat question from earlier.
Yes.
Scott, do wholesalers only need one certificate to sell cigarettes, OTO, nicotine pouches, and e-cigs?
Yes. I mean, yes, one tobacco certificate covers all.
All right, this is Mackenzie. If there are multiple locations under one owner in different states, and we transfer product across the state lines into Indiana, do you have to have the wholesale certificate to transfer that product outside of a retail permit?
So this is, once again, you're talking about inter-corporate transactions.
Yep.
Same guidance applies as earlier.
Okay. This is from Shady. If you have a distributor manufacturer of hemp products and sell no tobacco products, we will not need any license through the ATC. Is that correct?
If you sell vape, THC vape, then you have to have a tobacco certificate because THC vape is an e-liquid without nicotine, and it falls within the definition of tobacco product.
Hey, Chris,
Yeah.
back up a second to Scott's question about do they need one certificate? The statute specifies a certificate is needed for each physical location you operate out of. So if you have
Okay.
multiple physical locations, the same as the
Yes.
TCs apply for retailers. So if you have multiple locations you're distributing from, then you're going to need to get a TC for each one of those locations.
But you don't need
So
a
wholesale.
separate certificate for e-cigarettes and cigarettes.
No, no.
Okay, perfect. Thank you, Shadi. I hopefully I answered your question there. The answer with the hemp products, if you sell THC vape, that is subject to, that's included in the definition of tobacco product, if it's a legal vape, obviously.
Okay, so next is the retail businesses who operating under retail TCs do not need to worry about this new law, right?
Yeah, that's right.
All right, another one from James. We have countless times reported over the past 4 years and video reception proof and was told there's not enough enforcement to do anything about it. How is it that fair you create a law that punishes though doing incorrect?
I got it, Melissa. This is the type of question that doesn't help anybody. Being accusatory in your questioning is not going to, it's not going to foster collaboration. So I'm going to shut that down now. If you have specific complaints that you'd like to discuss and locations you'd like to discuss, I'd be happy to have those conversations. I suggest that you contact the, in fact, you know what? Send me an email offline, James, and I will connect you with Superintendent Miller, and you guys can have a conversation. The better way to go about asking a question like this, without question marks, is to ask how I can escalate an issue, or to ask to have a conversation offline about a frustration you have or something. So just going forward, let's not be passive aggressive. Next.
All right, next is from Hamid. Are foreign country made vapes going to be banned in Indiana on July 1st?
Foreign adversary ban, foreign adversary made vapes, and we're going to get to that next bill. So actually not the next one, but the next one. Yes, foreign adversary vapes will be banned, and we'll talk about that in 1 sec. Good question.
This was from Raymond. DOR will be aligning with FTA uniformity standards. Once this change is implemented, will enforcement use the data provided to DOR to identify contraband sales?
If you are to be aligning with it. Oh, sure. Yeah, we work with DOR. We have a memorandum or a data sharing agreement with DOR. Absolutely. We work with them and collect that data. Good question. And that's a useful way to illustrate the ways that we work together and the data that we use to identify bad actors. And to get back to James' concern, I don't want to minimize that concern because you guys are out there trying to comply with the law. You're charging the taxes, you're collecting the higher price as a result, and it's not fair when you have other businesses who aren't. So I really get that frustration. However, we can express it in a more positive way going forward, maybe more constructive.
All right, this is Mackenzie. Can you tell us the banned countries that we can't get a hold of to stay in compliance? I think we're going to talk about that in a little bit. Lisa's question about emails, Lorianne answered that. You can check us out on our contact page, and Lorianne put a link in the chat. So thank you very much, Lorianne. And I think that's all the questions. So if you want to move on to the next.
Hey,
All right.
Melissa.
Yep.
I'm sorry.
Melissa, there's some stuff in the Q&A.
Oh, I did not check that. So, okay, thanks.
While we're here, yeah, okay, I got these, Melissa, because I can see them. I got it open.
Okay.
Do retailers in Indiana need to maintain a bond for e-cigarette tax certificate? That is a GOR question. I don't know if there's a bond or not, but I will get you guys answers on that bond inquiry. I don't think there is a bond. There certainly isn't one on the ATC side. Is the state going to have a list of wholesalers who are licensed so retailers can know? Great question. Yes, we'll maintain a licensed wholesaler list. We will definitely do that for you.
Okay. There's a couple more questions about the foreign adversary ban.
I'll get to that when we get to the foreign adversary section.
Yeah.
So we got your questions recorded. I'm going to go explain, because some of them I answer in my presentation. So if we're good on the, what is this? Confirm that the requirement comes effective July 1. Are we talking about the foreign adversary ban?
Which question are you looking at?
I'm looking at effective date and enforcement. Under Raymond Chu. Oh, okay, yeah, it is distributing. Oh, no, distributing without a certificate. Okay. So yeah, the wholesale certificate I think you're talking about becomes effective July 1. Yes, we are providing a grace period, as I said in my presentation a couple times. We aren't going to do. We won't cite and cite for failure to have a certificate until after November 1 of 2026. We'll give that grace period. And we are going to have an enforcement transition period that is from July 1 till November 1, where we will do educational enforcement. And we will be reasonable thereafter in working with people for a reasonable amount of time. What penalties apply if wholesaler continues distributing without a certificate after the effective date? That would be depending on the circumstances. I can't really talk about what individual penalties would occur, but if you're operating without a certificate, then you are violating a couple of statutes. I think they're a misdemeanor for selling without a certificate, without a TC.
Class A infraction.
Class A infraction. And then if you're also selling illegal stuff, then you might have a corrupt business operation, and you could be racketeered. So it really depends on the facts.
Chris,
All right.
Yeah,
I think fines, suspensions, and revocations would also be.
if you don't have a certificate.
Oh, if you don't have a certificate, thank you.
Yeah. We could fine you though, right? So that's true.
So Raymond had an earlier question too. What are the specific application requirements for a wholesale tobacco sales certificate? Are there any additional requirements for a wholesaler, such as floor plans, inventory
It's all
controls?
exactly the same. It's all exact. I think you might have missed earlier in the presentation, Raymond. It's all exactly the same as the retail requirements. It's like all they did is update the statute to create the wholesale, and then the word certificate now means retail and wholesale. So literally all of the requirements that apply on the retail side from qualifications to compliance requirements apply on the wholesale side. So that's an easy enough transition from a compliance perspective.
All right, another one from
the bond question. Sorry, I'm in a little bit of a roll here, Melissa. On the bond question, we don't have. Nothing's changed in that regard. That's okay, Raymond. Can retailers form a buying? Joe, I'm guessing you're meaning a co-op maybe or something? Mr. Lackey? Melissa, I'll let you take back over. I'm sorry, I don't want to get out of that rhythm. You see Victor's question?
Yes, sorry, I put myself on mute. If your company manufactures and sells only to their own company, what license applies? And I think we've kind of covered that, but Chris, if you want to.
Yeah, if you're a manufacturer and you're manufacturing e-liquid, for example, you would have to have the e-liquid manufacturing certificate. There's a cigarette manufacturer's permit as well. And so that would cover those instances. I guess it depends on what you're manufacturing in terms of what certificates you need. But then in terms of internal distribution, then there's no wholesale requirement for the internal distribution of your own product within your own commonly owned businesses that are then selling to external. So you don't need a wholesale for that.
Okay, so I think that's all the questions in the chat on the Q&A. I think you've already answered all those, so I think we're good.
Great, thank you, Melissa. Okay, so getting on to, and I know I put a time frame on this webinar. It can go on as long as it needs to go on. I blocked out until after lunch, so if we need to talk for a long time, it's no problem, guys. So don't worry about the time limit. Okay, so SEA 144, the vapor and e-liquid advertising was this bill. Real simple bill here, theoretically, anyways. So there's a word in Indiana code currently. It's vapor product, and the word vapor product, for whatever reason, was used to describe a device. So only the device without the e-liquid. So the word vapor product means device without any e-liquid product. Kind of confusing. So we just updated it and we changed that word from vapor product to vapor device. So now in Indiana code, a device without e-liquid is referred to as a vapor device instead of a vapor product. You can't say the government isn't trying to be more efficient. Look at that. So vapor device, again, is a device without the e-liquid. And a goal there just being clear description. SEA 144 also prohibits advertising of e-liquid within 1,000 feet of school property. So this means that you can't, if you are located within 1,000 feet on your physical business, you cannot have e-liquid advertising. You can't advertise e-liquids. You can't have like e-cigs or vape advertising on your property. This is kind of like, well, I won't use that analogy. This is only for within 1,000 feet of school property. This would also include, of course, like actual standalone billboards, anything like that. I want to note too, SEA 144 is not ATC's bill. So the exact target here, there may have been examples of tobacco locations that were located within 1,000 feet and school property, and we're doing this. Not 100% sure. But going forward, if you're within 1,000 feet of school property, you need to make sure you're not advertising e-liquids. And then the other big change from 144, probably have a minor impact, but there's an age restriction now imposed on vapor devices without e-liquid. So if you are selling a vapor device without the e-liquid, you can only sell to people who are 21 or over, right? And then if you are a person who is under 21, you cannot purchase a vapor device without. So all this does is impose the existing age requirements for tobacco on the e-liquid device itself. And then let's see, let me put that there. That is it for SC 144. I doubt there's a ton of questions. The terminology, well, current tax interest. Oh, so when we do legislative changes, when we are updating the code, there's a team called the Legislative Service Agency. Connor, he's asking what impact does the changes in terminology have on the vape tax? Because the old code, that code uses the old terminology. We make sure that any references to the word that we're changing or the definition we're changing are updated as well. Sometimes it's missed. Obviously, we aren't perfect, but SEA 144 should have updated every reference in Indiana code to vapor products to make it vapor device. To the extent that any of that is missed, we will, the new definition will control, and we'll update it next session. So you want to read Joe's question?
May retailers form a buying group to obtain quantity discounts, OTPs maybe, and can the product be shipped to a single location and distributed to the group without a wholesale TC?
That's Jessica, I wonder if you have input on this. This sounds like a co-op.
I think we haven't talked about it, so I can't say.
Yeah. It's a
But
good
we can
question,
add that to
Joe.
the list of questions.
Okay, perfect. I thought that was the case. Joe, thank you for that. That's a good question. And Joe Lackey is with the Food and Fuel Association. So when we were talking about, bringing questions to the ATC and bringing complaints forward about businesses, those industry associations are great ways to aggregate and represent complaints and concerns of the industry. So Joe is a good resource for you guys out there.
Next is from Tabitha. Distinguishing between vapor product and vapor device helps with the distinguishing between what is a closed system versus open system.
Sorry, I said Food and Fuel. That's Matt's group. It's grocery and convenience stores. Matt Norris is the IFFA. Can you read that again, Melissa?
Distinguishing between vapor product and vapor device helps with the distinguishing between what is a closed system, OTP, versus open system, ECG.
So we've eliminated the distinction, I believe, completely in Indiana code between open and closed systems. Have we not, Alex? And now they are all just called vapor products.
As of July 1, that is correct. But however, in the criminal code for minor possession of these products, the product was always covered, whether it was open or closed. However, on the distribution side, as a retailer selling it to a minor, there was no crime for the retailer selling just the open system device to a minor. So now you are correct. There is no distinction. If you sell any part of it, it would be a violation.
Okay, and I think that is all we.
Okay, that's it.
Let me check the Q&A real quick.
Sweet. And we'll talk more about that, distinguishing the vapor product stuff. We'll talk about that in this next bill. So maybe we'll help a little bit more, Tabitha, in answering your question.
Okay, I think we're good.
Okay. So moving on to SEA 185, this is the e-liquid manufacturing permit. This is a big change in the state of Indiana. There's no doubt about it. And it's a big undertaking for the ATC as well as the industry. I said this during my state or the general webinar, legislative update webinar, but industry groups, individual industry members, individual permit holders were extremely involved and helpful and supportive in finding language that will properly regulate e-liquids in the state of Indiana, that will create a healthy marketplace, and hopefully getting back to some of the issues we talked about earlier, a fair marketplace where bad actors are successfully weeded out. As we look at legislative changes, one of the things that we're looking to do is to increase ATC's ability to take action against bad actors. And in some ways we're limited, and that's obviously purposeful because we don't want to have an agency that's out there being, dictatorial. So we try to be balanced in how we develop and grant authority to the ATC. But regulating e-liquids was something that really needed to happen in the state of Indiana. Once these products became more common, as vaping replaced cigarettes, the regulations didn't catch up or keep up with the manufacturing industry, with foreign adversary countries who are manufacturing dangerous products and then shipping them into the state of Indiana. So Indiana, and the feds, FDA did not do a lot and hasn't done a lot to nip that in the bud in terms of taking enforcement action and controlling that marketplace, and also approving products that should be approved for sale in Indiana. So we had to find a balanced approach here that would result in the safest marketplace we can make without creating an unfair situation for permit holders. So that was our goal and objective in developing and passing SEA 185, and I hope we accomplish that. And we're going to do everything we can to work with industry to implement this law and then to also enforce it after it's implemented. So I want to start with the foreign adversary product ban. So SEA 185 bans e-liquid products manufactured or sourced from a foreign adversary. They cannot be sold in the state of Indiana unless they have an approved or pending application with the FDA. So this means that if a product is made in one of the foreign adversary nations, which are right here, next slide, I have the 5 nations listed, and it's China, Cuba, Iran, North Korea, and Russia. If a product, an e-liquid product is manufactured in any of those countries or is sourced from any of those countries, it is not allowed for sale in Indiana unless that product has a pending or approved application with the Federal Food and Drug Administration. The foreign adversaries, who is a foreign adversary, is defined by the U.S. Department of Commerce, and the banned products are referred to as foreign adversary products. So as we go through this presentation and in the law itself, the word foreign adversary product is an e-liquid product that is banned from sale in the state of Indiana because it is manufactured in or sourced from a foreign adversary nation. So this ban includes products with ingredients sourced from an adversarial nation. It does not include vapor devices or the components without the e-liquid. So the vapor device, the batteries, all of that stuff, the mechanical components, the electronic components, I know that like almost all of it is sourced from China. We know that. We received that feedback early on. Our goal is not to ban stuff because it's made in another country. Our goal is to restrict bad stuff, dangerous products, right? So these mechanisms are not our target, so they're excluded from the bill. They can come from wherever you buy them from. The FDA approval or pending status, that ensures that the products are being vetted by a subject matter expert, and it allows us to have some comfort that the products are not dangerous because they haven't been denied yet or they haven't not been looked at by the FDA. So again, that goes back to the goal here. It's not to go after products from a place just because they're manufactured in that country. The goal is to go after dangerous products. So here are the current foreign adversaries. These don't change often, but I say that and things change quickly these days. So it's always possible that they would change. So it's China, Cuba, Iran, North Korea, and the Russian Federation. And most foreign adversary products that are unvetted and will be illegal in Indiana, they come from China, and those products will be banned unless the manufacturer demonstrates that they have FDA approval or pending status. So the e-liquid manufacturing permit itself. So manufacturers selling e-liquid products, and e-liquid products is the new term we use to define all e-liquids that are sold in the state of Indiana that are legal. So manufacturers selling e-liquid products in Indiana must be permitted by the Alcohol and Tobacco Commission by January 1 of 2027. Every e-liquid product sold in the state of Indiana has to have an underlying e-liquid manufacturing permit, and all Indiana manufacturers must be permitted. To qualify for a permit, applicants must comply with FDA product quality and production requirements. They don't need FDA approval because only a handful of products have FDA approval, but they have to verify and comply with FDA product quality and production requirements. They have to verify that they do not contain harmful and potentially harmful constituents. Those are HPHCs. HPHCs are ingredients, chemical compounds that have been identified by the FDA as harmful and are banned for use in products in the state or in the United States. So those HPHCs are listed on the FDA's website, and it's not. I don't think we'll see a lot of HPHCs in domestically produced products. These applicants also have to register their manufacturing facilities with the FDA, which has been a requirement for a long time. So again, have to comply with FDA quality and production requirements, and have to make sure that they're not selling foreign adversary products. Manufacturers can obtain an Indiana permit for e-liquid products that are not approved or pending with the FDA. You don't have to have an approved FDA status or a pending FDA status, so long as you can demonstrate compliance with the FDA product quality and manufacturing regulations. So this does not apply to a foreign adversary product. Again, if you're a foreign adversary product, you have to be pending or approved with FDA in order to be sold in Indiana. This applies to non-foreign adversary sourced products, so products made in countries that aren't, or sourced from countries that are not foreign adversaries. You don't have to have FDA approval or pending status, so long as you can verify that you're complying with all the FDA requirements for manufacturing and quality. The Indiana e-liquid manufacturing permit terms. So it's a 2-year permit. There's a $3,000 initial fee and a $1,000 renewal fee. The applications must contain a full list of products manufactured by the applicant. And I think we'll probably get into a lot of the questions, I'm just guessing, that are being asked in these next few slides as we talk about our plans to implement the bill. So applications have to contain a full list of products manufactured by the applicant. If the product is not FDA pending and it's not FDA approved, the application has to include all the ingredients. If it's an FDA pending or approved product, all we need is evidence of FDA status, and there's an FDA tracking number that is provided for all products that are pending with the FDA. We'll use that tracking number as proof of FDA status. And in the event that a permit holder has a product that is denied or otherwise has a change of status with the FDA, then you need to let the ATC know. If there is a product that is not pending or approved by the FDA and the FDA takes action to prevent sale of that product, that would also be something that we would need to know immediately. Permittees must also report new products during the term of the permit, and that will be reported via the existing annual e-liquid manufacturer report. So under Indiana code, there currently is a requirement that open system manufacturers have to obtain a permit from us currently. And in that existing statute, there's a requirement that those permit holders provide annual reports. And those annual reports have to list any new products and any changes in ingredients. So that annual report will be required of permit holders. So here we are to more of the implementation side of things. So we're going to maintain a comprehensive green list. And that green list is going to be the full list of products that have been approved as part of the e-liquid an e-liquid manufacturing permit. So the permit requirement is effective January 1, 2027. So we're going to start receiving applications imminently and start receiving product lists imminently. So between now and January, and then the months after that, where we'll have a bit of a grace period to allow applicants to continue to trickle in, we will be compiling that green list, and our enforcement will be educational primarily, because we'll have a very limited ability to go out and really identify a product as unlawful, because we aren't for sure if there's a pending application or if there will be an application before the end of the grace period. So by probably March of next year, we'll have this comprehensive green list available. It'll be a list of every product that we have vetted, but that has been listed and proved to be illegal for sale in the state of Indiana. And the products that are not on the green list are unlawful for sale in Indiana until an e-liquid manufacturing permit has been obtained. Enforcement of manufacturing permits for individual e-liquid products will be narrowly tailored until all applications have been filed on or before January 1, 2027 and are processed by the ATC. So foreign adversary products, ATC will publish notices for newly identified foreign adversary products, but we don't plan to maintain a published list because the green list will control. If the product's not on the green list, then it will not have been approved for sale in the state or vetted for sale in the state. The ban on foreign adversary products is effective July 1, and we'll start to do slow enforcement upon the effective date. And what we'll do after this effective date is we identify foreign adversary products. We will publish notices that will leave out for like a certain period of time. Probably in this period between now and January, we'll probably keep that, keep a list of foreign adversary products we've identified up on our website. But once that green list is comprehensive and is done, then that green list will control, and it won't matter if a product's not on the list, then you know that it's not allowed to be sold. So we don't need to have a list of products that aren't allowed, because any product that's not on the list will not be allowed. So there are some miscellaneous tobacco changes also in SDA 185. One is that there is now an ID checking requirement for tobacco sales. So under the existing law, there's no requirement that you check a business owner check a person's ID to sell them tobacco. That requirement is now implemented. There's a prohibition on sleeping quarters and TC locations. This SDA 185 also includes all the wholesale provisions we already talked about. They're all identical to the other bill. Then there's the new cigarette buy-down language, which I've copied here. We can talk about that a little bit, maybe, but that is something that we're kind of dealing with as a separate issue. But again, I'm happy to take questions about that today. It's essentially loyalty discounts that are accounted for in minimum pricing. So then two other changes: the habitual status for a TC holder with multiple sales to minor violations is now 3 violations instead of 6. So under current law, if you have 6 sales to minor violations in a year, you're a habitual offender. Under SDA 185, effective July 1, that'll change to 3 violations in a year. Same to minor entry, minor loitering. Okay, so now we'll get to questions. I've seen some questions already, just kind of in the side of my eye, and I know this is something I want to address with sincerity, but I just want to make sure that the conversation doesn't go off the rails. I know that there is a lot of angst and anger about the FDA registry requirement. The state of Indiana has not adopted the FDA's registry. The FDA's registry includes less than 50 products. We recognize that, and there are about 8,000 products pending approval with the FDA. We recognize that a large number of products that are most likely perfectly safe have not been approved yet by the FDA, but they're pending approval, or they're otherwise complying with FDA requirements and just haven't gone through that regulatory process yet. We are not adopting a registry. We are not requiring or doing any sort of like the parallel regulatory scheme to the FDA in that context. We have a unique arrangement that's a bit of a hybrid. We use the FDA as the subject matter expert, and as obviously they are the federal entity. So they have the supremacy clause, which trumps state law that is inconsistent with it, right? So we are tracking the FDA, the subject matter experts. They regulate food and drug stuff. They know what's a dangerous product, what's a dangerous ingredient, et cetera. So if a product's been vetted by the FDA, then we can safely assume that it's safe, right? If a product is pending and hasn't been denied by the FDA, then likewise, we can feel safe that we can feel good allowing that product to be sold because the FDA has an application, they're aware of the product, they haven't denied it or otherwise taken action to prevent its sale. So those are the two. One track is you have FDA status or FDA approval. The other track for being on the green list is that you verify you comply with FDA requirements, but you don't yet have an application pending. So in that way, we've created an exception to FDA approval or FDA pending status in a sense by allowing you to demonstrate compliance with FDA requirements, which are best practices for industry and you should already be complying with under federal law. Otherwise, you would be subject to being shut down and criminally prosecuted under federal law. So you can have pending status, approved status, or demonstrate via verification and your ingredients list, et cetera, on your products that you're conforming with FDA requirements, even if you haven't obtained approval or don't have a pending application. So with that, I'll let Melissa go through the actual questions. I'm going to go off camera for a second, but I'm listening.
Okay, and I just want to point out too, sometimes it sounds like your mic is going in and out. So maybe just be mindful of that. I think the first couple are similar. So will there be a published list of e-liquids that we can sell? Will you be sharing a list of items pending FDA approval? And how will state verify that products have a pending PMTA? What information should be obtained?
Okay, let's see. So yes, we'll have a green list. The green list is a list of products that are allowed to be sold. I'm going to go up to the question so I can read it while I'm answering you. Who asked that one, MB?
Chris B. Key was the first one, and like I said, I think these are all similar, so we're
Okay,
trying to group
okay.
them together.
Perfect. Okay, to clarify, e-liquid product. Okay, sorry. I'm sorry. Can you read it again, Melissa?
Will there be will there be a published list of e-liquids that we can sell? Will you be sharing a list of items pending FDA approval? And how will state verify that products have a pending PMTA? What information should be obtained?
Fantastic. Yes, we will have a comprehensive list that we'll call a green list of products that have been submitted and demonstrated compliance with the requirements to have a permit. So we'll have a list of products that are allowed to be sold, e-liquid products that are qualified for sale in the state of Indiana. We will maintain that list for you on our website. The next part of the question was regarding the PMTA. So as I said earlier, you don't have to have an FDA status to obtain an e-liquid permit, but it's one of the ways to obtain approval from Indiana without having to provide a whole bunch of other information to us so that we can vet the product properly. We will use the tracking number. There is a number. Is Jeff Coyle on the call? Because he identified a trusty way to track these things, and I have to go back to my notes to pull up the exact name of the number. But there's an identification number tied to each e-liquid product, each e-liquid application that's pending approval with the FDA, and we'll use that number as the evidence of FDA status. And then we can check the FDA maintains a database where you can search that number and it will show you the application. So that's how we'll verify if there is an FDA status pending or approved or whatever it might be. And the information you have to provide is that number. Go ahead, MB.
All right, so next is from Chris. So to clarify, e-liquid products means bottles of e-liquid and disposable e-cigs that contain an e-liquid?
It means any e-liquid, any product that is e-liquid, a vapor product, a product that is not rolled tobacco or any other tobacco product, a product that is an e-liquid. It means all of them. It doesn't mean the device without the e-liquid. That is called a vapor device, and it's regulated separately. But otherwise, an e-liquid just refers to the whole universe of vape products.
Okay, this is from Raymond. Is the prohibition limited to finished products, or does it also apply to the individual components and ingredients used in those products?
So when it comes to components, I'm guessing you mean chemical, but as I will reiterate that the actual electronic components like the battery and the device, those are not banned under the foreign adversary ban. You can get those from wherever they're currently being supplied. In terms of the parts of the product, yes, if a product contains ingredients that are sourced from a foreign adversary, they are subject to the foreign adversary ban. Otherwise, what you probably end up with is a product being offshored from a foreign adversary to a non-foreign adversary nation, the ingredients being compiled and created in the foreign adversary nation, then shipped, and the finished product being made in that third-party destination and then shipped to the United States. It would be a very easy rule to get around if we allowed component parts, ingredients, but not the finished product. So yeah, ingredients sourced from a foreign adversary are included in the definition of foreign adversary product.
Okay, this is from Melissa. What are the pending application requirements? Is there a submission date requirement for the PMTA? And is there a certain stage of the PMTA process a product must be in to qualify?
No, there's not. We did not include the submission date requirement. Other states have done so. In the interest of collaboration and really trying to create a system that gives a fair shake at becoming a qualified product for sale in the state of Indiana, we did not impose a submission date. So any status date is fine. And then in terms of the pending application requirements, demonstration that the application has been submitted and exists and has been accepted for review by the FDA. There's a number that you get, a tracking number associated with your application. That would be the number that we utilize and that we'd ask for. What we will do is we will use that number and we'll search it in the FDA's database of applications. And if the application status is denied or like temporary enforcement stay or something along those lines, then that would not be adequate to be sold in Indiana because now you have an FDA adverse status. But otherwise, just pending or approved are those are the two statuses that are required. Alex, there are a couple of other statuses we discussed. There's like several different statuses you can be with the FDA. Can you maybe list those if you have them handy?
So I believe that you're going to have a pending status, a granted status, a denied status, or you can be an appeal status. If for instance, you were denied your PMTA, you can appeal it. And if you're working off of that appeal, I believe we're going to allow you to continue to have your product in Indiana if there's an appeal being sought.
Yes, agreed. That we will. Perfect. So those are the statuses. And what I am also going to do, this written response that I get out to this group, it's going to include answers to specific questions. I'd also will provide sort of a narrative overview of the e-liquid bill and the requirements and what our plans are. That will sort of be a supplement for you to have, so you have an easy cheat sheet and understanding what the law is and isn't. So I will include in there maybe some of the more technical terminology that we pulled out and have in our implementation plans.
Okay, next is from MTK. Does this include disposable nicotine products like Mr. Fogg, Geek Bars, etc.? Will those types of products be banned if they are made in one of the banned countries?
If they are made in a foreign adversary country, then yes, they will be banned. I don't want to speak to any individual product at this point in time. But yes, if it's a foreign adversary product, it's going to be banned. And those products you listed are, I think, Spree bars are nicotine analogs, but the Geek Bar and the Mr. Fogg are both e-liquids. So yeah, they would be banned if they're a foreign adversary product.
Okay, next is from Melissa. If a device is manufactured in China, but the e-liquid is sourced and filled in the U.S., does that meet the Indiana requirements? E-liquid product equals disposable vape.
So e-liquid product equals disposable and refillable. It's any e-liquid, like the e-liquid cartridge that you would put in your existing device. It's like the open system and closed system. They're all e-liquid products. The device without any e-liquid in it, that's the vapor device. That's a separate term. And the vapor device, that can be sourced from anywhere. So to answer your question, you have the vapor device you get from China, which is like all of them. But you get a product, your actual e-liquid is sourced from a non-foreign adversary country like the US. That's totally fine. As long as you can verify FDA compliance with the basic requirements for production and quality, then yeah, that's fine. Good to go. Not subject to foreign adversary ban.
Okay, next is from Adam. Just to make it clear, if a product is made in China, for example, and is pending PMTA, it will still be legal for us retailers to sell?
That's correct, yes. Because again, this goes back to the fundamental purpose. We're trying to interdict and prevent the sale of unsafe products. It's not about where the product comes from. So if you have a product made in China that is pending with the FDA and is going through the process of becoming approved and the FDA has not rejected that product for approval, then yes, it'll still be allowed to be sold. What we'll have to have though, and this is probably a key sticking point, is the manufacturer of that product has to apply for the e-liquid permit with Indiana and demonstrate that the product has a current pending FDA status. On a similar note, I know that there are domestic companies that are manufacturing products in foreign adversary nations. There's at least one that I'm aware of. And that product is pending approval with the FDA. So in that case, again, even though the product is being manufactured in a foreign adversary nation, it's going through the vetting requirements to demonstrate safety. So it would be allowed to be sold. It would not be a foreign adversary product because it has an FDA status. So the foreign adversary ban only applies to those products that they've got no FDA status. And in other words, the state of Indiana, we have no way to verify safety or to have any sort of reassurance as to the safety of that product, which we would have if the FDA were vetting it, right, as the subject matter experts on the federal level with the Food Drug Cosmetics Act to rely on. And the problem here is that a lot of these foreign adversary products, these Chinese products that aren't trying to go through the proper channels, they are dangerous products. And that's the impetus for needing to eradicate those products from the marketplace.
Yeah, I think Melissa has a very similar question. I'll just read it. So if we have a disposable vape device that is fully manufactured in China, but it's a pending PMTA that has been accepted by the FDA, does that meet the requirement in Indiana? If so, what documentation is required by Indiana?
Yes,
I think
it does.
you just answered that.
Yeah, I did, but I'll just reiterate that it's not on the retailer to show us that their product has meets the requirements to have an e-liquid permit. The manufacturer has to obtain that permit because we need a direct connection, a nexus, as I keep saying, to the actual manufacturer. They have to ask us for that approval. It cannot be the retailer. Retailer, your only obligation as a retailer, as a wholesaler, is just making sure the products are on the green list. And if you want to reach out to your manufacturing partners and let them know, hey, your product isn't on the green list in Indiana, you just need to go obtain that permit. Yeah, more power to you, but it's not on you. And there's nothing you can do to obtain approval for a product if you aren't the manufacturer.
All right, so the next question I think is asking, does a green list equal a registry? So do you want to answer
that? Was the corner of my eye, and Connor already said that he understood the distinction that we're making. He's expressing the frustration and hesitation that a ton of industry members had at the beginning of this process, that what we were doing is adopting the FDA's 40 product registry, and that's not what's happened here. So, and then Connor already confirmed he understood that. So,
okay.
But it's a good point to clarify. So I thank Connor for asking the question.
All right, and this is from Adam. If a product is made outside of the foreign adversary list, does it mean it does not need to have a pending PMTA?
Yeah, if you're not a foreign adversary product, a pending PMTA is not required. In that case, the manufacturer would have to provide the full ingredients list for each of their products, that the ATC can then make sure that there's none of those, what are they called? The harmful products. Shoot, I want to give you the name again. The HBHCs, the harmful and potentially harmful constituents. So that list of ingredients, we would look at you have no FDA status and you're not a foreign adversary product, you apply to ATC for your permit, you provide your product list and your ingredient list for each product. We're going to go and make sure that none of the ingredients are one of those harmful products, whatever it was. I still can't remember the damn acronym. But make sure none of those ingredients are in there. You're going to verify that you comply with all FDA's production manufacturing requirements. You have the manufacturer's registration from FDA, which again has been a long-standing federal requirement, and you'll be good to go.
Okay. The next question is, would that list technically contain hemp vapes as well?
Thank you, Shadi, for asking that question. No, the ATC is not going to provide implicit or express approval for any hemp product. So if you have e-liquids that include THC, most certainly, and you manufacture those products, most certainly you should submit those in your list of products, but we aren't going to put them on our list, and our enforcement of the green list is not going to, we aren't going to use the green list to say, hey, this weed vape here is illegal because it's not on the green list. That's not how this is going to be enforced. This is tobacco, right? Food Drug Cosmetics Act, in the context of e-liquid manufacturing requirements, it applies to tobacco products. It doesn't apply to THC products. So we are not going to approve or not approve THC vapes. Our enforcement with relation to THC vapes, hemp vapes, will continue as it is currently. That is to say, if the product exceeds the maximum THC allowance or contains some other controlled substance, then theoretically it can be subject to being confiscated through some sort of investigation and formal process. But no, this is not a hemp related process. If you are an e-liquid manufacturer, you need to give us all your e-liquid products. What we'll probably do in the application is include in the products section, a separate section for THC products, and expressly state in there that the ATC is not taking a position as to the legality. Hopefully that makes sense, and we'll try to put out some written direction along this lines, but enforcement of hemp and THC related products won't change. Now, I will say if it's a China-made product, then that might get wrapped up, will get wrapped up in the foreign adversary ban, because that's illegal, not because it's hemp, but because it's a foreign adversary product.
Okay, so next is a question from Christine regarding if the presentation will be online. Yes, it will, and I think somebody posted the link on the chat. Next is, if the list is out on January 2027, how will we know which vapes are banned on July 1st?
Great question. The manufacturing permit, the green list, none of that comes into effect legally until January 1. So between now and the beginning of next year, you can continue operating as you are, save for foreign adversary products. So what you need to be mindful of as a business owner is, are you selling products that are foreign adversary products? Are you selling products that are sourced from a foreign adversary nation? And there you do have an obligation to verify whether or not your products are illegal in that context, effective July 1. And this may go back to an earlier question. I can't remember. Maybe it was maybe Lisa that asked about the PMTA and asking your manufacturer or your distributor for the PMTA for an adversary product. Between now and the beginning of next year, while we don't have a green list because the manufacturing permit is still not a requirement, you will need to, if you have a foreign adversary product, you do need to check if it has an FDA status, because if it has an FDA status, it's not going to get taken as part of the foreign adversary ban. So hopefully that makes sense. You need to start worrying about the green list and your inventory complying with that green list at the beginning of next year. Between now and then, you can start preparing for that. By again, talking to your distributors and your manufacturers, asking them to demonstrate that they're not a foreign adversary product, or tell me which products are made in a foreign adversary nation, that kind of thing. And if all the help that we can do in the meantime, we're going to provide. So for instance, as we identify foreign adversary products, we will send notices out and publish that so that you all are aware of what is a foreign adversary product. And this is my personal, this is my guess, is that all of the products you're currently selling, other than foreign adversary products, Chinese products, are probably going to apply for a manufacturing permit because they're going to want to continue to distribute in Indiana. Other states have this requirement as well, and there hasn't been a massive disruption in the marketplace for e-liquids. You've just seen around the edges those dangerous products be taken off shelves and no longer being sold in the state. But the vast majority of e-liquid products are going to be able to demonstrate that they comply with the requirements for the permit.
Okay, the next question is, where can brands apply for the manufacturing permit?
Great question. That will be online as well through My License One. And that application is still being built. It's as you can see, it's a lot for us as well as for you guys. So we hope to have that permit application done within the next week or so.
Okay, so the next one is from Missy Holly. There's currently no list of items that will be banned on July 1st. With that being said, will retailers have to take the loss on all items currently in stores that will no longer be sellable? And then I think she's making a comment here. Retailers need lists immediately for disposable vapes that are legal or illegal. Either list works.
Yeah, understood completely. There will be no list because there is no requirement regarding the e-liquid permit until January 1. So until January 1 of 2027, there is no requirement that you have an e-liquid permit to sell your e-liquid in the state of Indiana, right? The only requirement that's coming in effective July 1 is the foreign adversary product ban. And we are going to have to identify what those products are. So it will be a process of us investigating and working with partners to identify and create a list of foreign adversary products that we will provide you. So those are the products that you need to not be selling. And we will help in the context of the foreign adversary ban on July 1 by publishing lists and product names that are not allowed to be sold as a foreign adversary product. Well, if you are in a newsletter or if you're a TC holder in our listserv, we'll send out emails when we identify new foreign adversary products. So everybody's aware of what the latest status is. Now, in terms of what eventually becomes part of the green list and doesn't, right now, you don't need to worry about looking for a green list and saying, oh, is this product on the green list? Between now and the beginning of next year, again, what you need to do is just make sure that you're working with reputable distributors and that they're selling products that comply with federal Food, Drug, Cosmetics Act and FDA. That's going to be your goal between now and the beginning of next year. It's just preparing to be compliant with that green list by making sure all the products that you're selling are at least pending with the FDA, or the manufacturers can verify to you that they are complying with FDA requirements and will obtain an FDA or a state of Indiana e-liquid permit. So I know that's not I can't tell you like July 1, these are the products you'll be able to sell January next year, but it's going to be a process, and we're going to work with our retail partners and our wholesale partners to enforce the law in a reasonable way and to work together to identify dangerous products.
All right, the next question is from Quick Stop. Are convenience stores able to employ 18-year-olds? Are they able to ring up tobacco items to 21-year-olds?
Yes, there's no permitting requirement for that. What is the rule for selling? Is it 18 for selling tobacco?
They can sell, so there's no age restriction on sale of tobacco products. So any employee can ring it up and sell it.
That's what I thought. Thank you, Alex.
All right, so the next question is from Aaron. For retailers, we must check ID on all tobacco transactions. That's a question. I know the guideline is typically under 40 years old. I just want to clarify, we are now required to check ID on 70-year-old customers.
No. Yeah, good question. I should have put this in the presentation. We added that tobacco requirement to the same code section that talks about being 40. So it's the same requirement as alcohol for tobacco. Like if the person looks under 40, then you have to card them. If the person is clearly an elderly person, then you don't need to card them.
And the next question is from Evan Davis. Will hemp-based products be included in the green list of approved products through the e-liquid manufacturing permit?
Evan, Shadi already asked this question. Come on. No, we're not going to list hemp products. We're not, and nothing changes with hemp compliance and enforcement in relation to this bill.
Okay, how soon would the green list be available, and how long before we have to get rid of items not on the green list? I think you've covered this, but
yeah, I have. I'll just say it one more time. Green list will probably be available and comprehensive February, March of 2027. We will do educational enforcement for months after that, probably. So we're going to keep having updates, and I think I could foresee us having another webinar or another sit down with this group like end of this coming year, where we talk again about where we are with implementation. So I'll commit to you all. We will have another sit down and be able to really give you firm updates on where things are with the green list, etc. But for now, just know that the green list probably won't be available till realistically March of next year in a comprehensive fashion. And between now and then, just be prudent and diligent in verifying the selling products that are compliant with federal law for an adversary.
okay, I think that covers the next question as well, but green list will be available in January 27, but what about between July 26 to January 27? What should we follow? And then Nick asks, do you have a list of foreign adversary products you'll be targeting that are definitely not able to be sold after July 1st? I think you covered both of those already.
Not yet. No, we're working on that. And unless there has been notice provided, we will be sending out those product names as we identify them. That's an ongoing project. So no, we don't have a list right now.
Okay, next is from Connor. New products hit the market every day. How often will the green list be updated so shops can make decisions on what products to bring in?
Yep. As soon as a an e-liquid manufacturer updates us with a new product, we are going to build our system in a way where as the products are added to the system and approved, they will go directly onto that list. So I would think that the manufacturer would be proactive, and before they do a market launch, they would get approval for that product and add it to the list. So the green list will be updated constantly as new products are added by manufacturers.
Okay, the next question is, to be included on the green list, does the requirement apply only to nicotine liquids, including products containing synthetic nicotine? If a juice product is not subject to FDA regulation, would it still be required to be included on the green list?
There is a definition of e-liquid that I'm going to put in. Do you have? Does anybody have that like a definition of e-liquid handy, like in a bill or something? Otherwise, I'm going to look it up in Westlaw and drop it in the chat. There's a definition of what is an e-liquid under Indiana law, and that is going to be what is subject to all of this. I know that there are some, like there are nicotine alternatives, nicotine analogs. Nicotine analogs are already banned in the state. But I would need to know like what exact juice product you're referring to that isn't subject to FDA deeming. Because the FDA deeming regs said essentially all vape products, all e-cigarettes, all e-liquid that is consumed through heating and vaporization are deemed to be tobacco products. So I'm not sure what products those are that you're referring to. So I can't really answer that one.
Okay, next is from Chris. Can a Chinese manufacturer obtain an Indiana manufacturer's permit, even if they have not submitted a PMTA, as long as they meet all other application requirements?
No, they cannot. So they have to be pending with the FDA. And this is because there is such a large volume of dangerous illicit products that have come in from specific foreign adversary nations. ATC has to rely on the federal government to vet those foreign products that have been identified as potentially dangerous. So we cannot rely on verifications regarding compliance for foreign adversary products like we can for a domestic product or a product made in a non-foreign adversary nation. But a Chinese manufacturer can obtain Indiana manufacturing permit, but they need to apply with the FDA and have rejected status, which that shouldn't be any sort of huge hindrance if their products are legit.
And Chris, to clarify, the definition of foreign adversary includes businesses that are organized under the laws of the nation. So if that manufacturer has its entity organized in China, then their products would not qualify. They could obtain the manufacturer's permit, they just effectively would never get a product approved because of the foreign adversary issue. Unless
the product had FDA status.
Yes.
Yeah. Yep. So again, to answer the question, the Chinese business, if they're located outside of mainland China, they might be able to obtain the permit, but in order to get their products on the market, they have to have an FDA status.
And the next question, with ID being required July, if I have a customer clearly visible over 21 and his ID is not on him, am I able to make the sale?
That's the under 40 rule. Alex, how do you guys enforce that in terms of if you saw a situation where a person was like maybe in their 30s and they didn't meet the 40 threshold? How is that usually enforced?
It's officer discretion based on whether it's a complaint or what the issue is, but generally make an effort to make sure that they appear at least 40, and I don't think you're going to have many issues.
Great. Cool.
All right, the next question is very similar. Currently, we are checking ID who looks under 40, but now do we have to check ID of everyone? Does not matter how old they look. I think we've covered that.
Yep, you're complying with the law. Yep.
All right, the next question is from Nick, and he is asking about specific products, which I think you said you didn't really want to talk about. From what I understand, Breeze and Geek Bar currently have pending FDA applications, but some of those products are sourced from China and Indonesia. Will those be banned effective July 1? Maybe you can just talk generally.
Yeah, and so those are examples of products that they have. I know that there has been a concerted effort based on conversations I've had with some of our friends that have met with me to talk about this and this issue, I know that there's a concerted effort for some of the Chinese manufacturers in particular to actually come into compliance and make sure that their products are meeting American standards of safety. So if there is a product like Geek Bar, for example, if that product has a pending FDA status, then they can apply for a manufacturing permit, and they would not be a foreign adversary product if they have that valid FDA status. Now, if the FDA issues an order forbidding sale or otherwise denies the application, then that's a different story. But yeah, that's like I've said, the Chinese manufacturers, that's not the problem. The problem is the safety of the product. And if we have assurance as to the safety of product, we don't really care where it's made. The foreign adversary ban is just a helpful reference to countries that have been demonstrated to sell dangerous products.
All right, the next question, are nicotine analogs banned in Indiana officially, like
Yes.
Spree Bar and ingredients such as Nixidone?
Yep. Yes.
Okay, as a retailer, we are working hard to sell the Chinese-made disposables. Is there any kind of grace period for retailers to continue to sell these after the July 1st deadline?
Absolutely. Yeah, we're going to work with our industry partners, and I appreciate that effort's being made now, and I hope everybody does the same.
So another question very similar. Is there a timeline for the stores to sell and get rid of the inventories made in foreign adversary countries, or is July 1st the deadline?
No, July 1st isn't the deadline. We'll work with you. We haven't even identified all the products yet, so.
All right, the next question's from Nick, but he's referring to a specific product. Do you want me to skip that one?
I think it's the same answer, which is that, yeah, okay, so after July 1, actually, let me make a point here. Once the foreign adversary ban becomes official, there's a requirement in SEA 185 that a foreign adversary manufacturer affirmatively verifies to the ATC that they have a PMTA status. So if that company is a foreign adversary company, but their products are compliant via the FDA roll allowance, then they would have to affirmatively verify that to us.
Okay. Should liquids containing 6-methyl-nicotine metatine or nicotinamide analogs be included on the green list? So sorry if I mispronounced those.
No, that's all right. 6-methyl-nicotine or metatine, I think that is like one of the examples of a nicotine analog. Nicotine analogs are banned for sale in the state of Indiana. So none of those products would be eligible to be on the green list. And for those who don't know, a nicotine analog is essentially a product that doesn't contain nicotine, but has a similar effect on the nervous system and is sold as a product that has a similar effect on the nervous system. So metatine is an example. So is Nixidone. Those are examples of nicotine analogs. And they are unlawful and they will not be approved as e-liquid products to be sold in Indiana.
All right, Ann is asking, how do we get on the email list? I don't know if you know that or if Lieutenant Antes is on the call.
If you have a TC with us and your email is in your permit file, and you're already on our certificate list, you can sign up for the newsletter on our website. If you just go to the atc.in.gov, there's going to be a sign up for the newsletter.
Jeff provided a link for them.
Oh, great.
To sign up in the chat.
Perfect.
So
okay, cool.
that's covered.
Thank you, Jeff.
All right, thank you, Jeff. Okay, the e-liquid and disposable products have on the package where it is manufactured. Is that enough? That's from Victor.
No, as I have said a couple of times, and probably after you entered your question, the manufacturer needs to affirmatively demonstrate compliance if they're a foreign adversary product. It can't just be like it says Canada, but it's Mr. Fogg and they're actually a Chinese company.
Okay, this one's from Connor. Again, I think we've covered this, but what measures can a shop take if they sell foreign adversary products that do have a pending PMTA between now and when the green list is published? Can we continue to sell the product or wait till the item is approved on the green list?
So if you know that it has a PMTA, again, I would really encourage you to reach out to your distributors and make sure that proper process is being taken to get the product confirmed with ATC as lawful. We, to the extent that there are popular Chinese products, foreign adversary products that have a valid pending PMTA, that is an issue that we are going to have to continue to look at as we implement the law. Let's put it that way. I would be glad, Connor, to have a conversation with you about specific products. If you want to shoot me an email, I think that might be really insightful for me as well, educational for me. So if you'll do that, Connor, I'd love to set up a time to chat with you.
The next question is from Mike. FDA currently has a list, do they not, that are approved ENDS?
We haven't adopted. There are like 45 or 50 products that are approved e-liquids, and they're definitely qualified to have an Indiana e-liquid permit. The ENDS, what is that? What, I can't remember that acronym. Is that the okay, yeah, sorry, that electronic nicotine delivery systems, right? Yeah, they have a list, but we aren't just adopting the FDA's list. We have our own process.
All right, next one's from Melissa. Can we submit the manufacturing permit with the paper
No.
application? Nope. Okay. This is from Chris. During the educational enforcement period, as a foreign adversary products are identified, will be allowed to clearance them out, or will be expected to throw them away?
What do we usually do with that, Alex, on products we've identified as illicit?
It depends. I think if we just identified them, we'd probably give them time to get rid of it. And then after a certain point, kind of like fair trade issues, if the list updates for cigarettes, we're going to give you a little time to update your pricing in order to make the adjustments from the list, and then take enforcement action thereafter.
I'll tell you what we'll do. What we're already going to notice everybody on the TC list as we identify foreign adversary products. So what we could do is say that there's a time period between notice and when we'll start taking them. So you have that period to get rid of them in a lawful manner. So I think that's what we can do to solve that for good faith actors. And what that time period is, we'll have to look at some other examples like the fair trade law, for example.
And the next question is from Deep, but hemp vapes liquid will require a tobacco license now, right? You covered this prior, I believe.
No, we aren't going to approve hemp products. You do need to, if you are a manufacturer, include all the products you manufacture on your application, including hemp products, but we are not going to approve or take any action related to those hemp products outside of what we're already doing with hemp compliance. The green list does not control on what is allowed to be sold in terms of hemp. If the hemp product is a foreign adversary product, then it's illegal as a foreign adversary product.
Okay, next is from Anne. If a tobacco license is suspended, can disposable vapes and THC vapes still be sold during that period?
No.
Okay, this is from Victor. The e-liquid bottles have where they are manufactured. The majority are USA based. So that may be a comment to an earlier question.
It's good input. You're right. They do. And that'll be useful circumstantial evidence for us to find what is a foreign adversary product.
Okay, the next question I'm not sure you'll be able to answer. I
Yeah.
heard MasterCard is stopping payments for
There's
vape
a-
products.
There's there was like what's the word? A petition from state AGs trying to pressure credit card companies like MasterCard to stop accepting or stop making payment on nicotine products. This isn't the law. I really doubt MasterCard will do that. They, but right now that's not the law or anything like that. There may have even been a bill that was proposed on the federal level, but it's all politics. I don't foresee that actually happening.
Okay, so the next question was about employees selling tobacco items. Lorianne answered that in the chat, so Lorianne,
Thank
thank
you.
you. Okay. So
That's a
Raymond
definition of
is
e-liquid from
asking,
Alex. Thank you. Okay, next.
Raymond is asking, will your list show both the effective date and expiration date, or will you simply remove the item from the green list? I'd rather see both dates displayed than just having the item removed.
Yeah, absolutely. It'll show both dates.
Okay, this is from Victor. Checking ID where the customer has already shown ID months or years ago and the staff knows them. Do you still have to card them again and again?
Yeah, if they're under 40, I mean that's just yeah.
This is from Adam. Just to make it clear, there will be a grace period after July 1st as educational enforcement.
Yep.
Okay, if the vape is made in Indonesia and built in USA, is it legal to sell after July 1st?
Indonesia is not a foreign adversary nation, so those products are good. The foreign adversary nations are Iran, Venezuela, China, Russia, and North Korea. So if it's in Indonesia, they're good to go.
Okay, I don't see any other questions.
MasterCard is already working with the FDA on this in Indiana. Yeah, that may be. I don't really have any information on that. I was just going based on what I'd seen in the news. So it's an interesting development. And as we go away from a cash-based society, electronic payment providers have a lot of power, don't they? Okay. Okay, so if we are through our questions, I thank you guys very much for participating. And I don't want my shortness in some occasions to be interpreted as not taking things sincerely or seriously. I do. I just want to make sure that we keep the conversation collaborative and civil. So we're going to send out a written document after this, or based on this presentation, with the answer to the questions you couldn't answer, and then a narrative on the e-liquids. Between now and then, if you need anything, reach out to us. Happy to, as time allows, to speak to individuals separately or have some of the staff. Let me get this. This law changes because of kids get vape. Yeah, the minor thing, the ID requirement. Yeah, that's pretty much it. Okay. Well, this recording will be available soon. And again, I thank you all for taking the time today. And make sure that you leave the meeting, because otherwise the meeting stays open and keeps recording. So thank you guys. Take care, y'all.